8:30 in the morning. All right,
February 14th?
at 8:30 in the morning, and you'll do the stipend order, Ms. Underwood?
Yes,
Judge.
I will. Thank you, Your Honor.
Judge, I can do a notice on that while I send out the fingerprints, if that helps.
Okay, never mind. You won't have to do a notice, Ms. Underwood. Miss Adams will do it. Okay. Okay. All right, you're all set, Mr. Spalding. Good luck. All right.
Yeah, thank you so much.
You're welcome.
Your Honor, I think Ms. Wise popped on to answer your questions from earlier regarding the.
All right. Ms. Weiss. Okay, Mr. Malaro.
Murphy is here.
Oh, Mr. Murphy's still here. Never mind.
Yes, Judge.
I don't know what I just did. Oh, okay. Mr. Murphy. All right. So Miss Weiss. So we had a meeting. I did not have the meeting. I believe my judicial attorney had a meeting with Phoebe Meir and some other people because there was some confusion about the pleas that are deferred on OWIs. So I just wanted to make sure you were updated on that. So today the plea offer, Mr. Murphy, is Mr.
Schweiker would plead as charged the OWI third. Under 771.1, it will be delayed a year. And if he completes supervision successfully, it'll be dropped down to a second at that point. So it'll be a second, a misdemeanor on his record, not the felony. Now, from my understanding of that statute, that allows for it. It allows for the court. It allows for the prosecution to do anything at that point. I mean, it could reinstitute the original charge. You could drop it down, or it can be dismissed. And then at that point,
Mr. Murphy, I understand that. That wasn't the issue. It was just some other issues we were having with paperwork and other things. So, I'm.
Yep, and I'm afraid of the conviction when it gets entered. And so if you do a delayed sentence and it's not entered for a year, then it's going to delay the year before it hits his lien. Can we?
He does not drive, Miss Weiss, just for the record.
Okay.
He's unable to drive.
Okay.
But going forward, it's good to know we should be doing a deferred, is what you're saying?
No.
No.
You can't do a deferred under that unless they were in sobriety court, I believe. Because that's where I think I myself have confused myself with it, because delayed and deferred are obviously different. Now the statute allows for deferred under.
Wait, hold on, Matt. What were you going to say, Jackie?
Can I have a brief breakout room with Mr. Murphy?
Yep.
Yeah.
Okay. All right. So, Mr. Murphy, I am going to pop you and Miss Weiss. There. Go ahead and have a breakout room. Okay. Let's see who I got. Tom Glazier. All right, so Miss Underwood, in the matter of the people of the state of Michigan versus Joseph Gary Robeson, file number 23-21534FH. I don't think that's him. Recognize him. I do not have Mr. Robeson or Robinson in my waiting room or in my courtroom.
He's in jail, Your Honor.
Yeah.
Well, that might be why he's not here. Oh,
that could
Becky,
be.
can I get Mr. Robinson from the jail?
Sure.
All right. I have Blake Barton, Miss Underwood. Do you have him?
Who?
Blake
That's Mr.
Barton.
Murphy's case, Your Honor.
All right. And Caitlin Whitcomb. Who's that? Matt Murphy. All right. Mr. Glazier, you're here on Miss Hannah Walt.
That's correct.
She's not in jail. She is not present, Mr. Glazier.
Okay. I don't think I've ever met with her, Your Honor. I think this is one that I don't know. The last thing I knew that I forget who represented our office. I think it was Sam, but she was supposed to go to a independent event or a psychological evaluation. Never did. I've never met this lady.
So this is in the matter of the people of the state of Michigan versus Lisa Marie Hannawalt, file number 2023-21232FH. I have John Glazier appearing on behalf of Ms. Hannawalt. I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial, although a bench warrant was issued for her failure to appear for a pretrial on July 26th of 23. And there also is, yeah. So this is pretrial release order. Oh, she got released on a PR bond back in September, and she failed to appear again. So I'm going to issue a bench warrant for her arrest, and I will set bond in the amount of $75,000 cash.
Hey, did I just get blamed for something?
No,
Mr. Glazier threw you under that bus hard.
Did you represent Miss Hannawalt in the past?
I did. You talking about Lisa Hannawalt?
Yeah,
Yeah, but then she hired Goldstein, I thought.
Oh, she did?
No.
Okay.
No, she did not hire Mr. Goldstein.
She hired somebody, I thought.
No,
Anyway, I don't know why she's not here.
Is this the UDAA case?
Yeah, there's like 4 charges.
yes.
Yeah, I thought she hired Goldstein.
No. All right. Well, I issued a bench warrant for arrest, and bond is set at $75,000 on the underlying file cash. There's already a warrant for the contempt of court, I believe. So
Going on my permanent record?
yes, sir. Okay. So I have the jail. Let's see who this
Thank
is.
you, Your Honor. That's all.
Hold
I
on,
have.
Mr. Glazier.
But that's all I have, Your Honor. I'm leaving.
Where are you going?
Back over to the other court.
All right, fine.
All right, thank you.
Thanks. All right, Chris.
That's Mr. Brown.
But, oh, Miss Underwood. I have Mr. Brown.
Yes, if I could just have a brief, very brief breakout with Mr. Brown.
All right, this is in the matter of the people of the state of Michigan versus Christopher Owen Brown, file number 2021-20325FH. I have Rhonda Underwood appearing on behalf of Mr. Brown, and I have Sarah Brenner appearing on behalf of the people. I am going to open up a breakout room. Hold on. Go. So I'm going to open up a breakout room for Mr. Brown and Miss Underwood. All right, go ahead and join that breakout room. All right, Mr. Murphy and Miss Weiss.
Your Honor, this is why I wanted to speak with him. This isn't the issue that we contemplated earlier. So I based on looking at his case, I offered Mr. Murphy an OWI second, which he said he and his client will plead to today. So I think I need to get the court an amended information. I don't know if you want to proceed with what you have until you get that. Okay.
Yeah, I'm gonna proceed today because it's difficult for him to get here.
Thank you.
So, all right. So I'm gonna stop my video so I can move my camera so Mr. Schweikert can see me. All right. So this is back on the record in the matter of the people of the state of Michigan versus John Lewis Schweikert, file number 23-21496FH. I have Matthew Murphy appearing on behalf of Mr. Schweikert, and I have Jacqueline Weiss appearing on behalf of the people. So Mr. Murphy, for the purposes of the record, so your client can hear you, what is the plea offer now?
Ms. Wise has offered for Mr. Schweikert to plead to an OWI second offense, which is a 1-year misdemeanor. And from my understanding, he would wish to accept that offer today. Is that correct, Mr. Schweikert?
Yes, it is.
Okay, so you understand instead of pleading to the felony under deferred, you're gonna plead to a 1-year misdemeanor OWI second offense.
Yes, I do.
Okay, all right, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, can you state your full name for the record?
John Lewis Schweikert.
All right, so Mr. Schweikert, you fully understand the new plea offer?
Yes, I do.
Now, do you understand the maximum penalty for this offense could be up to 1 year in jail? Do you understand that?
Yes.
And it will result in a license suspension, but you've already told me you don't have a driver's license.
No.
Okay, good. Are you not good, but I'm glad. Okay,
Wow.
so are you satisfied with Mr. Murphy as your attorney and the advice that he's given you?
Yes, I am.
All right. Now, other than pleading to the OWI 2, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with this court. Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
Is that correct, Mr. Murphy?
Yes, Your Honor.
And would you agree no one spoke to me about what your sentence would be?
Correct.
Okay. Now, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes, I do.
All right. How do you wish to plead to the charge? And you understand all your rights, correct?
Yes.
All right. So we're going to add account 3, OWI second offense. So is that correct, Mr. Bayonetto?
That's correct, Your Honor.
All right. Mr. Goldstein, would you like my staff to let you have?
I'm actually going down to meet with Ms. Wise.
Okay. Okay. All right. So how do you plead to the charge that on or about June 24 of 2023 in the city of Adrian in the county of Lenawee that you did commit the offense of operating while intoxicated, second offense? Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to get you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any threats or promises or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Murphy?
No, Your Honor.
Mr. Bayonetto?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No, he hasn't.
Is it your own choice to plead guilty?
Yes, it is.
All right. So, Mr. Schweikert, on June 24 of 2023, were you operating a motor vehicle?
Yes, I was.
Okay. And were you in the city of Adrian?
Yes, I was.
Were you driving down East Church Street?
Correct.
Okay. And had you been consuming alcohol?
Yes, I was.
All right. Would you agree that your blood alcohol level was 0.08 or higher?
Yes.
Okay. And that it impaired your driving?
Yes.
Okay. Are you satisfied, Mr. I'm sorry. And you have a prior drunk driving from, well, I have one about February 24th of 1999 in the district court for Monroe County. Is that correct?
Yes.
Okay, so that would be a second offense. Mr. Bayonetto, are you satisfied?
I am, Your Honor, yes.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Malaro, Mr. Murphy
Yes, Your Honor.
and Mr. Bayonetto?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the district court probation department for a pre-sentence investigation. So even though I'm felony court, it's a misdemeanor plea, so it'll be handled by Mike McCarron down in district court probation, okay? So I'm going to set sentencing for February. Let's see, Ms. Adams, we said January 4th, right?
January 5th was the last one we used.
Okay, so I'm going to set this for sentencing. Can I get a notice of sentencing from Mr. Schweikert? So I'm going to set this for sentencing on January 5 at 8:30 or 8:15 in the morning. Now, do you want to come in person or via Zoom?
I don't even know how to say.
Okay, all right, so I'm gonna put it in person, okay? Okay, so a couple things. I'm gonna get you a notice of hearing for sentencing to come back in for sentencing, okay?
At what time?
We do sentencings at 8:15 in the morning. So you'll get a piece of paper that says January 5 at 8:15 in the morning. Is this your driver? This is someone who brings you?
Yes, it was today.
Okay, so yep, so you'll have to get a ride that day. But then next Thursday morning between 8 and 12, I need you to come to district court probation on the first floor and check in to see Mr. McCarron.
Can I have paperwork that says? that?
Actually, let me get Mr. McCarron up here. Hold on. Let me see if I can get Mr. McCarron to come up today. Because, all right, hold on. Yeah, I'm gonna see if Mike will come up today. Hey, it's Anna Marie. So I have a gentleman who just done there too. He doesn't drive. It's kind of private. Listen. Thanks, bye. All right, so Mr. McCarron is kind enough to said he'll talk to you today, okay? So when you leave here, take the elevator down to the first floor, go to the end of the hall on the right, you'll see district court probation. Ask to speak to Mike.
And Judge,
And,
he's gonna have to get set up for an alcohol substance abuse evaluation, which they could go over that with him in district court too.
Yep, you're gonna have to have an alcohol assessment and they'll give you the paperwork on how to do that, all right? Okay, so when you leave here, go downstairs, talk to Mr. McCarron, Mike, and then you have to have an alcohol assessment and we'll see you back on January 5 at 8:15, okay? All right?
This is the only paperwork I need to know to be here at the.
Yep, that's when you gotta be here for sentencing, and as long as you go to Mr. McCarron today, he'll tell you what you need to do otherwise, all right?
That's downstairs.
That's downstairs, first floor. All right,
Thank you.
thank you, have a good holiday, thank you.
Thank you, Your
All
Honor.
right, Mr. Murphy, I have one other of your people, if you wanna take care of it, or you gotta go.
Yeah, I can take care of it.
Okay. All right, I think it's, oh, yep, Caitlin Whitcomb. All right. I don't know why I got all the heavy hitter prosecutors come in. I got Ellison Arnold, I got Mr. Hartung. Okay, who do I have from the jail?
Joseph Robinson.
All right, and okay, hold on. Mr. Schweikert. All right. Caitlin Whitcomb, hold on.
Oh,
Hello, hold on one second.
all right.
Rhonda, do you need a breakout room with Mr. Robison? So Caitlin, what's your last name?
Married is Whiteman. My maiden name is Whitcomb.
Okay, that's like way too confusing for a Wednesday morning. All right. I was laughing because I was like, oh my gosh, did we do our paperwork wrong? Okay. So this is in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whiteman, now known as Whitcomb. File number 21-20579FH. I have Matthew Murphy appearing on behalf of Miss Whiteman, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial conference. We are set for trial on November 21 at 9 a.m. Mr. Murphy, are you prepared to go to trial?
Your Honor, could I have a breakout session with my client, please?
All right, so Ms. Whitcomb, I am going to open up a breakout room. And I'm going to close that other breakout room. So hold on a minute.
All right.
Miss Underwood, do you need a breakout room with Mr. Robison? Oh, wait, I got Mr. Hold on. All right, so Mr. Murphy and Miss Whitcomb, go ahead and join that breakout room. All right, Miss Underwood, back on the record in the matter of the people of the state of Michigan versus Christopher Owen Brown.
Yes, Your Honor.
Yep, Miss Underwood, how would you like to proceed today on behalf of Mr. Brown? Oh, she's ignoring me.
Your Honor, we've offered that the defendant could plead to an attempt with a delay.
Hold on, I don't have her attorney. I don't have his attorney.
Sorry.
Miss Underwood's not responding, so hold on.
Okay, sorry, Judge.
It's okay. Usually
I'm
she probably
talking
just...
and talking. That's funny. Okay, here we are.
Okay, so Miss Underwood, Miss Brenner was going to place the plea offer on the record.
Your Honor, I've offered to add a count 2 of attempted failure to pay, dismiss count 1 and the habitual offender notice, give the defendant a delay of sentence to continue making the payments as he has been, which is $225 a month. And if he's able to pay in full, then I would reduce the charge to a misdemeanor disorderly person. Miss Underwood just messaged me and asked if he could have another adjournment to continue payments. I don't have an objection to that, but that is the offer, and I will keep that offer open as well, so long as his payments.
Okay, very good. All right, Miss Underwood, how far out would you like this adjourned?
That January 10th, I think, looks good, Your Honor.
All right, so Mr. Brown, I am going to adjourn your pretrial to January 10 at 8:30 in the morning. I truly appreciate the effort you're making.
Thank you, Your Honor.
And it's only to your benefit, so that's great. And we'll see you back on January 10 at 8:30. And Miss Underwood,
I will do
this.
an adjournment.
Yep.
Thank you.
Thank you, Your Honor.
You're welcome. You're all set, Mr. Brown.
Okay, thank you very much, Your Honor. Have a blessed day.
You too. Miss Arnold, I sent you a chat. All right, so Miss Underwood, I have your other client, Mr. Robinson.
Yeah.
So this is in the matter of the people of the state of Michigan versus Joseph Gary Robinson, file number 23-21534FH. I have Brenda Underwood appearing on behalf of Mr. Robinson, and I have Sarah Brenner appearing on behalf of the people. This is the date and time set for pretrial. Miss Underwood, how would you like to proceed?
Your Honor, if I could just, I spoke with Mr. Robinson, but I've spoken with Miss Brenner again, so I just need a brief breakout.
Okay, so I am going to jail 2. All right, you should have gotten an invitation to join that breakout room. Who represents Blake Barton is Matt Murphy. Mr. Murphy, I lost Mr. Murphy. Mr. Malaro, are you taking oh no, he's in a breakout room. All right, Jeff, if we want to take a 2-minute break, we can do that. All right, we're gonna step off the bench for just a moment.
Judge stepped off the bench for a quick break, Rhonda.
All right, Mr. Robinson and Miss Underwood. Miss Underwood, if you're talking away, you're still muted.
Your Honor, we've offered in this matter that the defendant could plead to count 1 as a second habitual. We've dismissed count 2 and dropping the habitual from 4th down to 2nd.
So plead to count 1, second offense?
Correct.
Habitual?
Correct.
So it'd be a 4-year failure to pay, and that would make it a 6-year.
Correct.
Ms. Underwood, is that your understanding of the plea offer in this file?
I've explained the plea offer to my client Your Honor, I explained to him that in most cases like this, at the very least, they are released at sentencing to attempt to pay. My client, I believe, wishes to avail himself of that offer, Your Honor.
Mr. Robinson, raise your right hand for me. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right, so the plea offer, Mr. Robinson, is to plead to count 1, child support failure to pay, which is a 4-year felony, with the second habitual offender conviction. So that means the maximum penalty would be 6 years in prison. Do you understand that?
Yes, ma'am, I do.
Okay, it doesn't mean you're gonna go to prison. It just means that could very well be the maximum penalty.
Right.
All right. So, is it your intention then to plead guilty to count 1 failure to pay with 1 supplement?
Yes, Your Honor.
All right, and are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, Your Honor.
All right, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
That's correct, Your Honor.
Is that correct, Ms. Brenner?
Yes, Your Honor, that's correct.
All right. Is that correct as far as you're aware, Mr. Robinson?
Yes.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am, I do.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right. How do you wish to plead to the charge that during the time period of July 1 of 2016 through January 31 of 2017, that you did commit the offense of child support failing to pay? Guilty or not guilty?
Guilty.
Okay. Would you also agree that you were convicted of attempted larceny? Wait, let's go with on April 23rd of 1991, you were convicted of breaking and entering a coin operated device and were convicted of a felony in the 39th Circuit Court of Lenawee County. Would you agree that you had that conviction? Okay.
Yes.
All right. Where did I stop before that?
Offense dates, you put the offense dates on the record, you gave them the residence.
Did I give them, did I talk to them like the right to stay, to remain silent during trial? All right, I think I skipped ahead. So, hold on. All right, I'm gonna back up. I probably already read this to you, but I got distracted, so I apologize.
That's okay.
So I think I got through. You have a right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. And I think I got through your appellate rights. I think if you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So, okay. So I'm going to ask you probably again, how do you wish to plead to the charge that during the time period of July 1 of 16 through January 31 of 17, that you did commit the offense of child support failing to pay? Guilty or not guilty?
Guilty, Your Honor.
And would you agree that was in the city of Adrian in the county of Lenawee?
Yes, ma'am.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood?
No, Your Honor.
Ms. Brenner?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Is it your own choice to plead guilty?
Yes, ma'am.
All right. And this is where I have ADHD, so this is where I squirreled. Ms. Brenner, there's restitution on both count 1 and count 2, and they both count. Is that correct? Because they're different time periods.
Right, so I would be asking for the full amount of the arrearages, which at this time, he's up to $34,638.
$34,683.
$638.10.
Oh, can't get that dime. Okay. All right. Okay. So, Mr. Robinson, during the time period of July 1 of 2016 through January 31 of 2017, you had a child support order in place. Is that correct?
Yes, ma'am.
So how many child support cases do you have? 1 or 2?
I got this one right here for my daughter.
Okay. All right. And you don't have anyone else that you're paying child support for, just your daughter?
No.
Okay. So during the period of July 1 of 16 through January 31 of 2017, you had a set child support order that you were supposed to pay. Is that correct?
Yes, ma'am.
And then also from December 1 of 19 through April 30th of 2020, you also had that set child support order that you were supposed to pay.
Right. And that's when the pandemic hit and everything, just 2 years of nothing. It was pretty rough, but yes.
Right. Yeah. So would you agree that you did not make your court ordered payment every single month?
I do agree with that. Yes, I'm fully accountable for that.
Okay. And the arrearage is $34,638.10. Is that correct?
Yes.
All right. All right. And let's see, Ms. Brenner, anything else on that?
No, Your Honor, the people are satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Ms. Brenner?
Yes, Your Honor.
I accept the plea. Oh, wait, one more thing. And sir, you were convicted, looks like on April 23rd of 1991, you were convicted of larceny under $100 in the 39th Circuit Court of Lenawee County, and then another count of attempted larceny under 100 on that same date. And then in 1991, April 23rd, you were convicted of breaking and entering a coin-operated device in the 39th Circuit Court of Lenawee County. Is that correct?
Yes, ma'am.
All right. Does that satisfy the second offense, habitual offender notice, Ms. Brenner?
Yes, Your Honor.
All right, so
Your Honor, may I be heard as to the issue of bond?
when I finish talking, you can. Okay, so I accept the plea. It has been understandably, voluntarily, and accurately given. This defendant has knowledge of his rights fully, and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Brenner, are you available on December 20th at 10 a.m. for sentencing? If you want to do a time.
Let's see. Yes, that's my birthday. So let's see. Yes, I can do that. You said 10 a.m.?
Yes.
Yes.
All right. And Miss Underwood, you're available, yes?
Yes, thank you.
All right. And the next question before I get to you, Miss Underwood, Mr. Robinson, you do have a right to appear in person for sentencing, but you can also Zoom in. So do you wish to appear in person or Zoom?
Either one's, I probably would be better with Zoom if I'm working, more than likely, because my job offered me my job back. So if I'm working, Zoom would be better. I do have a good cell phone for that and a library to go to.
Okay, where's your job?
At Pioneer Transformer.
Okay, where's that at?
I was scheduled to go back to work on September 5th, but I got arrested on September 4th on Labor Day. I've been here 60 days.
All right. So Miss Underwood, I guess you wanted to address bond?
Yes, I do. Thank you, Your Honor. Your Honor, what we want is payments, obviously. I think in this case, since I believe his son works there as well, since Mr. Robinson does have a job to go to, I think, Your Honor, if he did not show up for his sentencing, I think Ms. Brenner would personally walk a absconding charge into the courthouse. I think Mr. Robinson has every incentive to get out, to get to work, and to arrive back at his sentencing with payments already set up, Your Honor. And that's my hope. I would ask, with this large of an arrearage, we need to get Mr. Robinson started prior to sentencing day. And I would ask that he be released on a PR bond. And the only thing is, he needs to go to work and provide proof of employment to the friend of the court no later than the end of next week.
All right. Ms. Brenner, any response?
Your Honor, I'll leave it to the court's discretion. He hasn't made any payments since 2019. There is an indication in my file of a history of domestic violence. So if you are inclined to release him, I would ask for no contact with Sally Rose while he's out pending sentence. If he gets out, if you allow it. But I'll leave it to the court's discretion.
Mr. Coast. I don't know if Mr. Coast is in his office. Maybe. All right, Mr. Robinson, obviously no objection to having no contact with Sally Rose.
Not a problem, ma'am. Can I say one thing? I have never met my daughter.
No, we're not going to get into any of that.
Okay, sorry.
Okay.
Sorry.
All right. Anything you can say could be used against you. So, all right. So I'm going to release you on a PR bond.
Okay.
I'm going to order that when you get out of jail, you report to see Mr. Coast. So you would come to the 3rd floor of the courthouse and check in with Mr. Coast at the clerk's office. And then Miss Holly, do you want him to check in at the probation department as well?
Yeah, we need an address and phone number right now.
Well, I can put you in a breakout room with them. But are you still in Elverton, Ohio?
Yes, I've lived there in the same house for roughly about 7 years.
All right, it's the same address on that information, Miss Holly, but I can put you in a breakout room. All right, so I'm going to release you on a PR bond. You are to provide proof of employment to Mr. Coast as well as to the friend of the court, so they can start taking out an income withholding. Now, is this a current charge case, Ms. Brenner?
Yes, Judge, it's charging at
All right.
$664.
So I suggest you get a second job, which a lot of people do. So, because you got to make your current child support order, plus you got to hammer away at your arrearage. So, Pierre Bond, no contact with Sally Rose. When you get released from the jail, I need you to report to the circuit court clerk's office on the 3rd floor and ask for Mr. Coast. So I want you to see him before you go anywhere today. Do you understand?
Absolutely.
And then when you're done talking to Mr. Coast, you're going to walk down the hallway to the probation department on the 3rd floor and get your packet of information you need to fill out and set up a time to meet with them. Mr. Coast, this is Mr. Joseph Robinson. I'm releasing him on a PR bond with no contact with the Sally Rose and to provide proof of employment to you and the friend of the court for an income withholding.
So
Okay.
sounds good, Judge. I'll be looking forward to seeing this afternoon, probably.
Okay, and then sentencing is December 20th of 2023 at 10 a.m. via Zoom. Miss Holly, I'm gonna pop you in a breakout room with him. So let me see here. Close up these breakout rooms. All right, Mr. Robinson, we've had a bunch of people in court this morning who have been hammering away on their child support arrearage. So it may seem insurmountable, but people do it.
Well,
All right.
I got a plan that'll probably, you won't believe it, but it's gonna happen, so.
Well, as long as it's legal, I'm happy.
Oh,
Okay.
yeah, absolutely, absolutely.
All right, let me find Miss Holly. Okay, I'm gonna open up the breakout room with Miss Holly. When you're done talking to her, you're all set, okay?
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Good day.
You too. All right, Miss Whitcomb is back, but I think I lost Mr. Murphy to his trial downstairs. Did you join the breakout room, Mr. Robinson? Yep.
Judge, I'm gonna cover Mr. Murphy's remaining files.
Miss Adams, and if you can let the jail know when Mr. Robinson's done, I will take Mr. Hyder, Miss Smith, or Miss Schermacher. I've not seen Mr. Fry on Mr. Dillard though. Okay.
Your
What do you have
Honor,
left? Yes.
I apologize.
James Derby. You're looking for James Derby. He was here really early. So let's see if this is him. He was here earlier. I think he had to go to work, but this might be him. Yep, that's Mr. Derby. All right. Connecting. Oh. He's trying to connect. Mr. Hartung, what do you have today?
I have Mr. Dillard with Mr. Fry. I believe he's in the other courtroom. I had a hearing with him down there as well.
I thought you were logging in to listen to the trial.
I can do that. I can do that too.
All right. So, I'm just, Mr. Derby.
Yeah.
Hi, Mr. Derby. Thank you for your patience. So
Yeah.
this is in the matter of the people of the state of Michigan versus James Edward Derby, file number 2023-21594FH. I have Rhonda Underwood appearing on behalf of Mr. Derby, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for arraignment in this matter. Miss Underwood, how would you like to proceed?
Your Honor, we would waive the reading of the information, acknowledge its receipt and the receipt of the witness list and the request for discovery. We would ask that the court enter a not guilty plea on Mr. Derby's behalf and set this out for a pre-trial, maybe January, Your Honor.
All right, what about January 17 at 8:30 in the morning?
That's fine, Your Honor.
All right, Mr. Derby, I will enter a plea of not guilty on your behalf. I will set this for pretrial on January 17th at 8:30 in the morning. My staff will prepare the notice of hearing because it's after arraignment. And it's the same Zoom number, Mr. Derby. So I'll see you back on that day, all right?
Thank you. Yes.
All right, thank you. Your bond's continued.
Yeah. Have a good holiday.
You
That
too.
was- That was January 17th, Your Honor?
Yes, ma'am. All right, Ms. Whitcomb.
Do I hang up now or what do I do?
Yep, I'm gonna disconnect you right now. Have a good holiday. All right, Caitlin Whitcomb, can you hear me? She's not connected to audio. Connect her. All right, so Hyder's in jail. Barton Blake is Matt Murphy. Mr. Malaro, are you handling Barton Blake?
Yes, I am.
I'm gonna let him in real quick. Miss Whitcomb is not connected to
I
audio.
don't see Whitcomb in our DD. Do you know? Could you spell her name?
No,
for me?
she's actually she's Whitman, but she married and now she's Whitcomb, which is all kinds of confusing.
That's okay.
All right, Mr. Barton, can you hear me? Mr. Barton?
Yes.
Okay, this is in the matter of the people of the state of Michigan versus Blake Anthony William Barton, file number 2023-21272FH. I have typically Matthew Murphy representing him, but Mr. Murphy, Mr. Barton is in a jury trial right now. So he is not available, but Mr. Malaro is going to step in. So I have Salvatore Malaro appearing on behalf of Mr. Barton, and I have Alexander Bayonetto appearing on behalf of the people. Mr. Malaro, just an update. I have a motion affidavit and show cause from September 11th stating that Mr. Barton failed to do a PBT on August 21 of 2023 in the afternoon, September 4 in the afternoon, September 6 in the afternoon, September 9th in the AM, and September 10 of 23 in the AM, and he consistently fails to charge his remote breath device. I received a letter yesterday from Mr. Coast, and which is updated to November 6th. He states that Mr. Barton is presently on a Scram device, and he is doing well with that device, as Mr. Coast has not had any reported violations. We tried twice previously with the sober link, but the defendant wasn't charging it properly and he was missing tests. The Scram unit costs $3.50 more per day, but he is being properly monitored with it. And Mr. Coast is opposed to going back on the sober link because we've already gave him 2 opportunities with that, and he was not successful. So Mr. Murphy, as I said, is not here. So this is the date and time set for pretrial. The plea bargain in this file was plead as charged to count 1, which is a 5-year felony. Mr. Malaro, how would you like to proceed today on behalf of Mr. Barton?
So Judge, just so I understand, he wasn't doing an original testing order, but he is now testing and he's okay with it?
So originally we had him doing PBTs on a remote breath device.
Okay.
And twice we did that and he wasn't able to keep it charged. He wasn't testing as required. And so we took him off of it and we put him on the Scram, and now he's successful with the Scram. That's all.
Okay, all right. So Judge, according to Mr. Murphy's notes, he's awaiting a transcript to complete a motion that he needs to file. It looks like this matter is set for trial, and Mr. Murphy is requesting that the trial date be vacated for him to get the transcript so he could file the motion. I don't know if the court wants to set some motion dates or what, but and then I guess we can adjourn the contempts as well. That'd be our request.
Okay, hold on one second. Miss Jane. Are you doing this transcript?
No, I'm not. Okay. No, I'm not. When was it?
I'm trying to figure that out.
No, I'm not.
All right, let me look at the order for transcripts. All right, so on August 17th of 23. Okay, so this is probably district court, Ms. Spade.
Looks like the request was put in.
Hold on, Mr. Milaro. All right. Can you check on it? Sure. Because it would be due November 17th.
Okay, I'll check.
Okay. All right. So Mr. Milaro, it would be due November 17th. So the pretrial is November 8th and the jury trial is December 6th.
Okay.
So he will have the transcript by November 17th.
Okay, today's the day for the pretrial. That's what today is.
I know. So I can move the, Mr. Goldstein, do you want let back in that jury room? You're not bothering me, but do you want let back? Because my staff can let you back. Okay. All right. Okay, so he wants the trial date removed.
Your Honor, he did. Sorry, Mr. Muller. Mr. Murphy and I did discuss this yesterday. He did indicate that was going to be his request, and I don't have any objection if the court does want to move it. I'm not sure we'd be able to get the motion filed and heard before that trial date.
All right, and he's not in custody, so this is a 1 day. I mean, drunk driving usually take 1 day. All right, Ms. Adams, I'm looking for a 1 day jury trial.
We did have it set for 2 day. Do you still want me to just look for 1 day?
Yeah, it's an OWI operating while intoxicated. That shouldn't take more than 1 day, as long as it's not a Wednesday start date.
Okay. About Thursday, January 4th.
January 4th at 9 a.m., Mr. Milaro and Mr. Banetto.
Let me look at his schedule.
That works for me.
January 4th, Mr. Murphy, all he has is a sentencing, it looks like. So that's good.
All right, so we'll set this for 1 day trial on January 4 of 24, starting at 9 a.m. Standard requirements, motion deadlines. Let's see, I'm gonna set a motion deadline for December, am I here December 20th, Ms. Adams?
Yes.
All right, I'm gonna set a motion deadline for 12/20 of 23. Jury instructions and voir dire questions, I'm going to ask that they be submitted by 12/20 as well because of the holiday. I do not do a deadline on pleas, and I won't do a final pretrial because this is fine as a final pretrial. He is charged with operating while intoxicated third offense, which carries maximum penalty of up to 5 years in prison. He has a DWLS second. Okay, so he's looking at maximum penalty with his sub of 7.5 years in prison. And is there anything else we need today, Mr. Milaro or Mr. Banetto?
No, Your Honor.
Just so I get it right, Judge, January 4th is the trial date, 9 o'clock, and December 20th is the motion date and all the
Deadline filed and heard by.
Okay.
Yep.
Then we're good, Judge.
All right.
Thank you.
We will get the scheduling order out. Mr. Barton, your bond conditions are continued and we'll see you back on that day. Mr. Malauer would even note that if some resolution is reached, that you could always bring a minute on a day, not a Wednesday.
Yes. All right, Judge.
Awesome. All right, thank you.
Thank you.
Thank you.
All right. So Miss Whitcomb, where'd she go? Lost her again.
Ms. Schermacher, Judge.
No, I guess I had Miss Whitcomb and she's gone. All right, Miss Schermacher, let me grab your file. This is in the matter of the people of the state of Michigan versus Tiffany Renee Schermacher, file number 23-21338 FH. I have Salvatore Malaro appearing on behalf of Ms. Schermacher and Allison Arnold appearing on behalf of the people. This is date and time set for pretrial. Mr. Malaro, how would you like to proceed on behalf of Ms. Schermacher?
Judge, if I could have a real brief breakout with Ms. Schermacher, 2 minutes.
Yes, you can. So let me close the room. All right, you should get an invitation to join that breakout room. Mr. Fry, I'm just waiting for a jail window from Mr. Dillard.
Thank you, Your Honor.
All right, Miss Adams.
Yes, Judge.
So on Spearman, can you see if there's a writ scanned for today? I don't have a writ for today.
Okay.
I'm gonna have to close the breakout room. I don't have time for breakout rooms today.
I do not see one for today, Judge.
Okay. All right, Mr. Malaro, I'm running out of time. I have a jury trial starting at 10:30 and my jurors will be getting here. So
I understand.
it's okay. So with Miss, your state. Okay, I'm gonna stop your sharing. Whoever did that.
I did it.
Okay, so Mr. Malaro, how would you like to proceed with Ms. Schermacher today?
Judge, it's been speaking with Miss Arnold on this matter. When I spoke to her last night, we're going to ask to adjourn this 3 weeks. I don't know if that's still the case. But I was also.
Judge, we had both Mr. Malaro and I were trying to get information from Jackson on what their plea offer is. I finally got some information on that yesterday after hours, about 7 o'clock last night. I'm not sure how much time Mr. Malaro needs to speak with his client, but he has the information, should have the information he needs now that she can make a meaningful decision on the plea offer.
I have about 3 more people I need from the jail, and she's in my jail room, so I won't have time for him to talk to her this morning. But I could set it over to another day this week or next Wednesday, Mr. Malaro.
All right.
Or if you talk to her and she decides to do something, I can bring her in any other day.
Right. Judge, also, the case to Jackson, the court there, as a condition of her bond, said she could be released for treatment. We're asking the court to modify bond in this case for the same purpose. That was what I was putting up on the share screen, was to show that the court there had authorized her to be released. She could be released for treatment. She's looking at a bed at Harbor Light. Is that what it is?
Yes, sir.
So I can set this over to next Wednesday. That'll give you time to talk to her about the case here. But Ms. Arnold, your position?
Judge, we would completely disagree with that. I think in speaking with the prosecutor assigned to the case yesterday, there might have been some miscommunication in Jackson County, but the plea offer there is for a prison sentence, which will be equal to or greater than the COBS the court gave here. I believe Ms. Schermacher would be detoxed and she's been in jail, and with all indications that she would likely go to prison on this offense, we would oppose release into treatment. Further, she's engaged in a pattern of drug trafficking for a number of years, supported by jail calls, her Facebook information, that sort of thing, and not just dealing small amounts, but large, transactions that were hundreds of dollars worth at a time, as were the 2 direct buys by law enforcement that happened here and in Jackson County. And in addition to dealing methamphetamine, she also was dealing cocaine and opiates such as fentanyl. So we believe the bond is appropriate. Release to treatment would not be appropriate. We'd be worried about flight potentially, and there's no reason to do that given the likely outcome of this case.
So Mr. Malaro, I can set it over to November 15, November 22nd, or November 29.
But just so the court's aware, and Mr. Malaro is aware, I will not be available next week on the 15th, but on the 22nd, I'm scheduled for a trial in Judge Olsaver's court, but I think we're actually going to finish on the 21st.
So, Mr. Malaro, the 22nd, okay?
Absolutely.
All right. Mr. Malaro, can you do the stip in order to adjourn?
Yes, Your Honor.
All right, Ms. Schermacher, your bond's continued, and I'll see you back here on November 22nd, okay?
Thank you.
Thank you.
Thanks,
Ms.
Judge.
Schermacher, could you let them know I'd like to see, if you could, I'd like to see Emily Smith next.
Yeah.
Thank you. Mr. Malaro, you are here on, well, you're going to be here on behalf of Ms. Underwood for this case. Hold on, the next one. Ms. Adams, you saw no writ, correct? Or Spearman?
On my end, I do know they have changed it up and they're doing emails, so there wouldn't be one in the file.
All right, Mr. Bayonetto, are you able to verify whether the prosecutor's office did a writ in the matter of the people of the state of Michigan versus Terrence Ray Malik Spearman, file number 23-21348FH? Rhonda's on this file, Mr. Malaro, but I wasn't going to make her come back if there's no writ.
Okay.
Well, MDOC has not presented him, so.
It says we did a writ.
For today?
For today, yep. Yep.
All right, well, they did not. Well, MDOC didn't present him. So I'm going to adjourn this to a couple weeks. So let's go to November 29 at 8:30 in the morning.
Who's this?
And I'm sorry, Mr. Malaro.
Who are we talking about?
Terrence Spearman. He's 23-21348FH. So I'm going to adjourn this to November 29th at 8:30 in the morning. And Mr. Malal, if you can do the stip in order, and Mr. Van Netto, you make sure the writ is done.
Yes, Your Honor. I'm
Again.
putting that in right now.
Again,
Okay, thank you, Judge.
thank you. All right, so that takes care of Spearman's. Let's go through who I need. James Hyder's in jail. Alan Graves. I'm ready on Alan Graves. Are you ready on Alan Graves?
Is he there?
No.
Yeah.
So this
Last I knew he was
is the-
released, Judge, and he was supposed to report every Monday.
Well, okay, so he's supposed to report every Monday to who?
I think Darren.
Let me check with Darren.
I know he showed up the other day. He was there.
Let's see.
This week.
Hi, this is Judge Ansel. I'm on the record. Elvin Graves. Have you had dealings with him?
The judge, did he arrive?
No.
Did he show? No, I have not. Basically, he tested positive for meth. Sent it to the lab, and confirmed it. He reported the next week positive for meth again. We have a warrant. He is supposed to show on Monday. He did not show.
All right, thank you, Mr. Post.
Thank you. Bye.
All right, so as I said, in the matter of the people of the state of Michigan versus Elvin D. Graves, file number 23-21428FH. I have Salvatore Malaro appearing on behalf of Mr. Graves, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for a pretrial as well as contempt of court sentencing. Mr. Malaro, as you heard, it appears he tested positive for methamphetamine and has failed to come in.
I don't know where he is, Judge.
Right, he is not in my waiting room, nor is he in the courtroom. So I am going to issue a bench warrant for his arrest. And I'm going to set bond in the amount of 75,000 cash. And that would be on the failure to appear for pretrial. And okay, that takes care of that. And are you Miss Smith?
Yep.
All right, good. I'll get your file. All right, this is in the matter of the people of the state of Michigan. That's what this is. All right, this is in the matter of the people of the state of Michigan versus Emily Anne Marie Smith. We have two files, 23-21177FH and 23-21352FH. I have Salvatore Malaro appearing on behalf of Ms. Smith, and I have Alexander Bayonetto appearing on behalf of the people. This is the date and time set for pretrial. Mr. Malaro, how would you like to proceed?
Yeah, Judge, I'm gonna ask to adjourn this. I don't see a plea offer readily.
Mr. Bayonetto, is there a plea offer in this file?
There is, Your Honor. Hold on, I have to pull up Ms. Mears' email. She offered as charged with with drug court, or if Mr. Malaro wants to talk to her about an alternative resolution, she would be open to that as well.
All right, it looks like I'll have to do that. I don't know that you weren't screened for drug court, were you, Ms. Smith?
No.
We'll have to put that in then. I
I
wasn't.
don't think we've had a request for screening, so how far out would you like to pretrial, Mr. Malaro?
Judge, it looks like she got 60 days on a contempt the last about 2-3 weeks ago. Is that correct, Ms. Smith?
Yep.
So
I'm almost done.
perhaps 2 weeks.
All right, so I will set this over to November 22nd at 8:30 in the morning. So ma'am, if you're not in custody at that point, you can appear via Zoom or in person. But otherwise, we will see you back on both files, November 22nd at 8:30. So I am all set with you, ma'am. Could you do me a favor and tell them that I would like to see, I saw him, I saw her, that I would like to see James Hyder next.
Okay.
All right, thank you.
Thank you.
And is Miss Carden present? Miss Carden from the jail. Is that today? Oh, that's this afternoon. Okay. Will you let Justin know that we're gonna need Jamie Carden at 1:15 in person?
Adam, you back up. All right, you're a wizard, Mary. Thank you, you're a fucking wizard, Mary. Well, don't do that while the judge is out there. I've got it. Oh. Oh. It's not a coffee. Better be on the check, but. Not be a two rooms. All in favor? Man, great. Are you log back in? Right here, we got it. Yeah, I did. Oh. A little quiet, right there. Okay, next we're gonna help together, great.
All right, Mr. Hyder.
Yes.
All right, grab your file. Okay. This is in the matter of the people of the state of Michigan versus James Allen Hyder. We have three files, 23-21589FH, 23-21511FH, and 23-21512FH. File number 23-21589FH is set for arraignment today. The other two files are set for pretrial. Mr. Malaro, do you waive the reading of the felony information on the arraignment file?
Yes, Judge, we'd acknowledge the receipt of the information, waive its reading in open court. If any defects in the time and place of service. Ask Mr. Hyder would stand mute and ask that the court enter a not guilty plea. We'd also acknowledge receipt of the witness list.
Excellent. All right, Mr. Malaro, and I have Alexander Bayonet here on behalf of the people. So, Mr. Malaro, how would you like to proceed today with Mr. Hyder?
You know, Judge, we were hoping to get a plea on so we could get him into drug court. I'm not
Has
sure
he
how
been screened for drug court?
He has been. I thought he was weren't you approved for drug court, Mr. Hyder?
Yes, sir.
But I'm not sure how this new case messes it, if it messes that up or not.
I mean, it's just, it's not just, but it's not a major delivery or anything of that nature. It's a possession. Is that correct, Mr. Bayonetto?
Yes, Your Honor.
So I don't know that it would preclude him from being in drug court. But I can set this over a week or two and you can discuss it with Ms. Teskey.
Yeah, and Miss Mayer as well, I suppose. I'm sorry, Mr. Hyder. I thought we could get this in today. Yeah, that'd be good, Judge, if we could set it over a week.
I'll just set this over 1 week, Mr. Hyder, so we can get you back in. So I'm gonna set it for pretrial on 11/15 at 8:30 in the morning. And I'll enter a plea of not guilty on your behalf on file number 23-21589FH. And I'll set all three files for November 15 at 8:30 in the morning. And Ms. Adams will do the notice of hearing for the arraignment file. And Mr. Malaro, can you do the stipend order to adjourn the 11 and the 12 file?
Yes, I will, Your Honor.
All right, thank you, Mr. Hyder. We're all set, and I'll see you back next week, and I'll talk to Ms. Teskey as well. Could you let them know I'd like to see Mr. Dillard next?
Yes, thank you.
Thank you.
And Judge, you have Whiteman yet?
She has been here all morning, and then she did a breakout room, and then she came back, and then she's disconnected. So do you want me just to adjourn it?
Yeah, Matt said she was gonna plead, but yeah, we can adjourn it.
Well, she's not there, and I don't know if she had to go to work or
Right.
whatever
I know
it
you
might
got
be,
that
but she's
trial,
been
so
here.
yeah, we can adjourn it.
So in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whiteman, file number 21-20579FH. This is the date and time set for pretrial. She is originally set for trial on November 21. So Miss Adams, I guess I could just set it over to November 15. So I'll set it over to November 15 for a pretrial, but Mr. Malaro, talk to Mr. Murphy, and if she is going to plead, just call Miss Adams and we'll get it in. Next Wednesday is going to be ugly.
Great.
Because right now we've got so many, I won't be able to do any breakout rooms next Wednesday. So I'll set it over to November 15, but if she decides to avail herself of the plea, we'll fit her in wherever Mr. Murphy is able to, okay?
Yep, understood, Judge. Thank you.
All right, so I believe, Mr. Malaro, that I have Mr. Fry and Mr. Hartung left. So I don't think I have anything left. Oh, actually, I do have one more thing. So in the matter of the people of the state of Michigan versus William Jr. Randalls, file number 22-20779FH. Rhonda Underwood is on this file, but Mr. Malaro is covering for her. And I have Alexander Bayonetto appearing on behalf of the people. This is the date and time scheduled for a request and summons for probation violation. We were originally here on November 1 of 23, and I believe he appeared, and I entered a plea of not guilty on his behalf. And he asked for court-appointed counsel, and I provided court-appointed counsel, and we adjourned it to today. And he has failed to appear. And a notice was mailed, a notice for today's hearing was handed to him because he did appear in person. So he's failed to appear, Mr. Malaro. At this point, I think I'm going to issue a bench warrant. If Miss Underwood I know she had not had contact with him earlier. If she has contact with them, I don't sign it for 2 days. So I'll issue a bench.
So it looks like she had, according to a note, November 1st, client needs to provide paperwork.
Yep. She was here with them and they actually spoke, and then I gave him service in person to appear today.
She's got some VOPs downstairs, it looks like, but I don't see any notes.
So I'll issue a bench warrant and I'll set bond in the amount of 50,000 cash. If she hears from them, say it again.
Is there a 48-hour hold on that?
Yeah, I don't sign any warrants for 48 hours.
Okay.
I think that's new court rule change. So, yeah, so if she hears from them, just let me know and we'll get them in. All right.
Yep. Thank you, Judge.
All right. So that takes, yes.
Did we set a new date on Darnez Johnson? I'm sorry if I missed that.
No, because you didn't give me a new date, because I knew MDOC said he wasn't available. He was being observed. So in the matter of the people of the state of Michigan versus Darnez Donald Johnson, we have two files, 23-21543FH and 23-21544FH. In the matter, Rhonda Underwood represents Mr. Johnson and Alexander Bayonetto on behalf of the people. Miss Underwood or Miss Adams, I'm sorry, usually you just send a notice out and I don't call it, so I apologize. I didn't know. So I'm going to set this for November 29 at 8:30 in the morning, and the people will have to send another writ out. MDOC called, he's under observation, so they weren't able to present him. So we'll need another email or writ like you've been doing it for that date, and then Mr. Malaro, in your office, do a stipend order to adjourn to November 29 at 8:30.
And what's the first name on this? First name, Judge?
Darnez Johnson.
Darnez. Okay. I'll get to it.
You're the best. All right, so that should take care of those. All right, Mr. Dillard, how are you?
I'm all right.
All right, let me grab your file. Ms. Adams, isn't this the second time Mr. Johnson wasn't available due to observation?
That is correct.
So, we might need a forensic. All right, this is in the matter of the people of the state of Michigan versus William Jarrett Dillard, file number 23-21360FC. I have Douglas Hartung appearing on behalf of the people and Brian Fry appearing on behalf of Mr. Dillard. This is the date and time set for pretrial. In this matter, Mr. Fry did file appropriate request for discovery back on October 26th of 2023. Mr. Fry, you've been able to meet with Mr. Dillard.
I have, Your Honor.
All right, and how would you like to proceed today, counsel?
Your Honor, so I have been able to meet with Mr. Dillard, and I've spoken with the prosecuting attorney, Mr. Hartung, regarding this case. I'm scheduled to pick up Mr. Dillard's file from his previous attorney today. Yesterday, they let me know it was ready, so I should be able to pick that up today. I'd be asking for an adjournment of this so I can review that file. It sounds like there is a resolution in the works that I think we'll be able to get in this case with a little bit more time for me to be involved in it. So if we could adjourn this a little bit, Your Honor, I think that would be helpful.
Hey, so I got a question, like how much farther is this gonna keep getting pushed back? Like I've been here going on 18 months, man. I'm not just trying to like keep sitting here, honestly, man. Like I know I'm not gonna get out today.
So, Mr. Dillard, I appreciate your frustration, but when you get new counsel, they have to have time to prepare and be ready to move forward. So, Mr. Fry has been fairly efficient about doing that. So, Mr. Hartung, any objection to an adjournment?
No, and for the record, just so we have a complete record on this particular file, Mr. Dillard was arrested on this particular file back on February 1st of 2023. And he's still being held on his parole holder as well. And I think the court has done a significant job working towards trying to accommodate all of those issues in this matter. I don't have an objection to an adjournment to allow Mr. Fry to get caught up. And as Mr. Fry indicated on the record, I spoke to him yesterday morning. There is a potential resolution in the works, and he needs some time to review that with his client, as well as review the background and do his due diligence in this matter. Thank you.
So, Mr. Fry, how long do you need?
Few weeks, Your Honor.
All right, what about, I have November 29 or December 6th?
I could do either of those.
All right, so I will set this for pretrial on November 29 at 8:30 in the morning. And we'll see you back on that day, Mr. Dillard. And you'll do the stipend order to adjourn, Mr. Fry.
Yes, I can do that. Mr. Hartung, can I sign your name with your permission?
Absolutely.
Thank you.
All right. Okay. Oh, Mr. Dillard's left. Okay. All right. That will conclude my morning criminal docket, and I'm going to take a brief recess before we continue our jury trial. Thank you.
Thank you.
About 5 minutes. stay?
Yes, Judge.
Take a break.
Okay, thank you, Judge.
I don't have exhibits.
Okay. Do you want me to get them marked?
I have stickers already.
Oh, do you? Okay.
So I'll just mark them.
Okay, thank you so much.
All rise.
Also.
All rise.
Great, you may be seated. This is in the matter of the people of the state of Michigan versus Alan David Crystal, file number 22-20896FH. I have David Goldstein appearing on behalf of Mr. Crystal and Isaac Sneed appearing on behalf of the people.